Hello, welcome to the second seminar of Schwegman, Lundberg, and Woosner's Life Sciences Seminar Series. I am Nicholas Lanzatella, your moderator for the series. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics in the life sciences in patent law. The seminars will be given on the second Tuesday of each month. And if you attend 3 or more of these presentations live, we will send you a free gift. So if you've attended the last one and this one, you're almost there. Slides for today's presentation will be available in the chat, and a link will be emailed to you also. If you have any questions, please put these in the Q&A. You'll see a Q&A button at the bottom of your Zoom. Put them in there, and the speaker will answer these at the end of the presentation if we have time. As a reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your legal counsel. I am pleased to introduce our speaker for today, my colleague, Stephen Reid. Steve's practice at SLW includes the procurement of patents and related counseling in the chemical arts, particularly in the area of small molecules and pharmaceuticals. He also conducts and advises clients on intellectual property due diligence investigations. He earned his JD from the George Washington University Law School and his PhD in chemistry from MIT. The title of his presentation is Patenting Solid Forms of Pharmaceuticals. Go ahead and take it away, Steve.
Well, thank you, Nicholas, and welcome everyone. Thank you for joining today. If you're in North America or similar time zones, I imagine this is about your lunch hour. So if you're enjoying lunch, thank you for joining in this presentation. A little history. I think all of us, or at least some of us who are old enough, remember as children, we sometimes got a crystal growing kit. And I was one of those kids and had a fascination with just the concept that certain compounds would grow into crystals, highly colored crystals, crystals of all different shapes and sizes and morphologies. And it's quite a leap to go from a children's toy all the way over to a diffractometer mounting single crystals on a goniometer, and which I did during grad school and through my postdocs in chemistry. So suffice to say, I've had a somewhat a fascination with crystals generally, and also as unique creatures in the area of science. Although I entered patent law later in life, like many of us who are practitioners, I came to appreciate that crystal forms or solid forms generally play a significant role in the area of pharmaceutical patenting. So today, the general overview of what I'm going to present are exactly what are solid forms and why should we even bother patenting them. Next, I'll go over some basic mechanics on drafting applications, patent applications directed to solid forms, and look at the law as it applies to solid forms. And at the end, a very brief comparison of US practice to some major jurisdictions around the globe and how they differ from the US in the patenting. I should point out that not in this presentation would be aspects of enforcement of patents directed to solid forms. That would simply exceed the scope, mainly the time scope of this presentation. So enforcement could be a worthwhile topic for a future webinar, as there is plenty to discuss. So what are solid forms? Well, this taxonomy chart I think would be instructive. The solid forms generally are divided into crystalline substances and non-crystalline substances. Typically in the non-crystalline side, We deal with amorphous forms, powders, disordered solids. A glass would be a separate category. Most of the time in patenting, we are dealing with crystalline forms, and these come in various um, uh, kinds. The single component are a single compound. It could be a crystal, even nanocrystalline forms. On the multiple component branch, we have not only the active pharmaceutical ingredient, the API. It might come as a salt, so there'd be one or more counter ions in a co-crystal. There would be the API plus a coformer, a neutral compound that, together with the API, enables it to crystallize. So here, hydrates where the coformer is water, solvates where the coformer would be a solvent like acetone or DMSO. And then we have other more specific species like molecular complexes, clathrates, and inclusion complexes. I should point out that in this presentation, I will try to refer to solid forms generally, but in the routine practice, a lot of these are crystalline solids and specifically polymorphic crystalline solids. And we'll get to those, but I sometimes use solid forms and polymorphs interchangeably, although it should be understood that the one is a species of the other. Speaking of species, the crystalline form I view as the ultimate species. And when it comes to patenting a single compound, it is strategic to have a patent claim that is directed to only one compound, which is a species. But the polymorph or the crystalline form of it could be even further um, narrower species. And that's because although the compound itself might already be patented or long known or even both, the focus here is not on the identity of the compound, but rather its solid state form. That is how it exists at the sort of crystal packing or crystal lattice level. And here we get into what are the polymorph, if it exists as a polymorph, amorphous solids, co-crystals, and the like. So in this regard, it's you have not only the compound, its identity, but also in how it exists on the shelf or in a vial in a specific form. Well, let's talk about polymorphs. So what are they? And I appreciate that the audience here probably cuts across a swath of legal experts like myself, technical experts, maybe both. So for some of you, this could be old hat, others maybe not so. So I'm having to catch up and make sure we're all on the same page. But in general, the word polymorph means many morphologies, and more specifically, is where a compound can exist as two or more crystals, obviously with the same chemical composition, but having different internal structures. And that's a little loosely stated. The internal structure, of course, we define with reference to its crystal packing in different unit cells and their dimensions. So if any of you have looked at crystal packing diagrams, you know exactly what I'm talking about. And uh, different compounds or under crystallized under different conditions can pack differently in the solid state. In contrast, a compound usually has just one amorphous form, and so it's incorrect to refer to the amorphous form as a polymorph because well, first of all, it's not crystalline, and simply it's not poly. There are not many of them. Well, the big question here is why are we even talking about patenting solid forms? Well, there are several reasons, depending somewhat on who is asking the question or for whom the question is asked. For drug innovators, solid form patents is a way to extend their market exclusivity. It's a way to build up a patent thicket around a drug, and in the The graphic here on the right, which would be a typical view from my home in Oregon, I like to use the word evergreening. That sometimes strikes some of the patenting community as a bit of profanity, but I think it applies. And simply the concept is to extend patent protection on a compound, first by coverage of the NCE via genus and species coverage, and then later in time, patent one or more solid forms of the compound. And in that way, one can extend total coverage of a compound more than the patent with a single patent term of a patent. Similarly, generics are and often do establish their own patenting thickets by later discovering solid forms of known pharmaceuticals. I should point out too, importantly, that from a regulatory standpoint, solid form patents can and are listed in the FDA Orange Book. Next, we'll turn to more of the mechanics of drafting patent applications directed to solid forms. And this is not a one size fits all. These are highly specific, fact-driven creatures of the drafting table and require a lot of cooperation between the attorney and the inventors. In general, though, the specification of a solid forms patent application must describe the advantages of the solid form. And again, I'm answering or addressing these topics from a U.S. standpoint, although some of these principles are broadly applicable around the globe. So some examples of the advantages that are highlighted would be the relative ease or maybe the difficulty in manufacturing a particular solid form. Those who have crystallized compounds at the bench know that the gross morphologies can vastly affect the handling of a compound. For instance, if they are fluffy needles, those are highly susceptible to static electricity. They cling to vessels and you can't really pour needles. On the other hand, if the compound crystallizes in nice cubes, it flows almost like a fluid. Hydroscopicity is another potentially important aspect to discuss in a specification. Some polymorphs are highly hydroscopic, others not so much. And while that in and of itself may not be important, shelf life and stability of a particular polymorph is important. So if a particular polymorph is particularly hydroscopic, it's probably not the one that's going to be found in a commercialized formulation. Turning to more of the pharmaceutical importance, and I'll touch on these aspects in more detail further slides, are aspects like, again, physical stability, as some polymorphs are, represent thermodynamic or kinetically preferred forms of a compound. How about chemical stability? And here I'm referring, of course, to what most people understand as shelf life. Different solid forms sometimes exhibit dramatic differences in solubilities in various solvents. And the last, which I'll discuss most in this presentation, are pharmacokinetic and pharmacodynamic parameters of various polymorphs. A couple of these parameters would be bioavailability, Cmax, Tmax, and the like. Now, solid form patents, say here, are rich with data, and that is not only descriptive, but prescriptive. They must be packed with data. at least if it's going to stand on its 2 feet around the globe. Now, this is a tall order for a basic patent where the drafting and the filing occur very early in a drug's life cycle, where at most a patentee or an applicant would have no more than some basic assays on the drug itself. But by the time a an innovator or an applicant generally would be looking at polymorphs, generally the applicant would have narrowed down the compound to a drug candidate, maybe even a clinical drug candidate, and at a point where things like salt screens and polymorph screens have already been carried out, and where though the emerging polymorphs have already been studied in some mammals, monkeys and humans would be examples. So it really is not a big ask of a patentee to supply um, rich data, not only physicochemical, but also in vitro and especially in vivo data. And here I highlight that in vivo data is essentially essential. And we'll get to that later. And turning more specifically to biological data, the um, the uh, uh, the timing, the drafting of a solid forms patent application obviously has to be late enough in order for such bodies of data to be generated and then captured in the application itself. Now, it's important, not so much in the US, but around the world in corresponding foreign applications, that as much data as possible is stuffed into the application. And while in the US, we can rely on post-filing declaration evidence of non-obviousness, that is not necessarily the case in other countries. Some glaring exception would be in Canada, which prohibits all post-filing evidence of non-obviousness. So whatever exists within the four corners of the application is all that is available to combat any allegation of obviousness. China would represent a somewhat middle ground between Canada and the US, where post-filing evidence is admissible, but only if it fits within the kind of evidence that's already contemplated in the specification. So for example, if this application touts advantages A and B attaching to a particular solid form, but post-filing evidence addresses properties C and D, it is highly likely that that post-filing evidence will not be admissible. Well, how is a solid form characterized? Again, if you're coming from the bench, this is pretty bog standard, but in a patent application, should look pretty much like a journal article. It's that high quality. So obviously how to make the solid form, whatever it might be in the case of polymorph salts, co-crystals, screening conditions. Then the experiments are described down to solvents and temperature ramps. How was the thing crystallized if it was a crystal? Were there coformers in the case of co-crystals? What are they? What are their ratios to the API and so forth? Physical properties are also described. Those should be pretty self-explanatory. And finally, the analytical data on characterizing the polymorph. I'll spend some time on this. I have highlighted here that X-ray powder diffraction is the gold standard for characterizing a solid form, be it amorphous or crystalline. And here, the facility, maybe in-house or a contract research organization, would be supplying a fairly thick report on how the experiments were carried out. This includes what instrument was used, the experimental error, the conditions like temperature of the data collection, the kind of radiation that was used, and finally an honest representation of or presentation of the data. I just give an example here of the typical uh, XRPD signal presented in terms of degrees to theta with an experimental error of plus or minus 0.2 degrees to theta. In some cases, an applicant also has a single crystal structure, which can be used in claims, and I'll get to this, to also characterize the polymorph. So here would be unit cell parameters. Um, Other techniques are also very useful in characterizing polymorphs. Various like IR Raman spectroscopy, solid state NMR, and thermal techniques like differential scanning calorimetry and thermogravimetric analysis. I've used most of these in typical solid form applications that I've drafted. Now, the specification also describes the use of a solid form. This isn't too complicated because the basic use of a solid form is the same as the basic compound itself. So if it has a an act, if the compound itself is a particular inhibitor at a particular receptor, well, so too is the solid form. Description of the therapeutic activity and efficacy. I'll return to these concepts a little bit later, but this is quite important. Sometimes or preferably a comparison of the therapeutic activities between the solid form to be patented and what's known, if anything, in the prior art about that solid form. And finally, if applicable, any aspects of the manufacturing utility of the solid form. And as an example, sometimes uh, it's found that the pure API cannot be produced. Maybe it's a particular enantiomer or diastereomer. It can't be produced except if a solid form of it is made in the first place. Finally, it's useful to describe the compositions comprising the solid form. Why? Because ultimately, one of those is likely going to be an infringing product, if there will be an infringing product. The note that in the case of crystalline forms like polymorphs, these do stay in the solid form within the composition, such as a tablet, a capsule, a powder. So it's important in the specification to describe pharmaceutical excipients that are not liquids, clearly because in many cases, the liquid itself would dissolve the solid form, which then would no longer exist as a solid form. So things like syrups, elixirs, liquid diluents ought not to be combined with a solid form. Well, let's turn to claiming solid forms. And here I'll take a little detour off into dactyloscopy for the patent attorney. For those who are unfamiliar with the term, dactyloscopy is the study of fingerprints as they relate to identification of human beings. I think all of us now have been familiar with this since childhood. And in well, at least criminal investigations or otherwise, the ridge patterns of our fingerprints are the things that enable two things. One, to identify a person and to differentiate that person from everyone else. I think we all know that every person, so far as we understand, has a unique set of fingerprints, allowing this identification and differentiation to occur. So notice here that we focus on the particular characterizing patterns of the fingerprints and not on the person as a whole. We don't need to describe Barry the burglar here and all of his physical features and what he looks like and how he moves. It is enough just to pick out some characterizing patterns, namely the fingerprints or features within the fingerprints. So how does this relate to claiming solid forms? Well, we need ridge patterns for solid forms. And that translates to claim limitations that differentiate between, in this case, polymorphs. And it's not enough to merely identify a polymorph using these limitations. We have to differentiate between them. And here I return to X-ray powder diffraction as the gold standard for carrying out this twofold task. First, if the solid form is amorphous, then the XRP, the X-ray powder diffractogram, usually will display one broad signal, in which case it's appropriate to identify and differentiate that amorphous form by the single signal degrees 2 theta. In the case the polymorph or the compound is crystalline, then the XRPD will show numerous sharp signals, which are the elements that will find their way into a patent claim. So how many signals should be chosen to differentiate and identify a particular polymorph? Well, the answer depends somewhat on where we're patenting. And again, for answering from a US standpoint, in an independent claim, 4 or 5 signals are usually sufficient to achieve this task. And this is where one point among many where coordination with the inventors really pays off. I will simply ask inventors to do this task for me. For instance, if there are 4 forms, 4 polymorphs of a compound, please look at the XRPD diffractograms and the peak listings and pick out characterizing peaks for each that are unique. In parentheses here, although I did tell you I'm not going to cover enforcement, it is important to realize that in the US under the all elements rule that to prove infringement, a patentee must prove each element of a claim for infringement. So it is much more difficult to prove infringement if for a claim that has, say, 10 XRPD signals as opposed to just 4 or 5. I will note, in contrast, that some countries do require more XRPD signals in the independent claim. Just from recent experience, those countries include Colombia and Israel. In dependent claims, it is appropriate to recite additional XRPD signals. Why do we do this? Well, the twofold task of identifying and differentiating polymorphs has to be straightforward. On the front side, it should be clear for the patenting so that patent examiners can differentiate, if necessary, between the claimed and any prior art polymorphs. Later on in enforcement or perhaps post-grant proceedings, courts also would be able to easily distinguish between the claims and any asserted prior art. Driving my point home, I've displayed here a real X-ray powder diffractogram indicating the various signals. And if you'll engage or indulge me in a bit of abstraction here, I've picked out features of fingerprints that are typically encountered. So for instance, a signal here could represent or correspond to an arch feature in a fingerprint, this signal here to a whorl, and this feature, the signal here to a loop. This is somewhat abstract because a single fingerprint might contain both a loop, whorl, and an arch. But the point is that the fingerprints, as they identify a person, correspond to an XRPD diffractogram or signals within it identifying a particular polymorph. So that's the rationale behind patent claiming. What are the elements of solid form claims? Well, here and throughout this presentation, I put real or somewhat synthesized patent claims in red boxes. And the basic form of a claim would be a crystalline, a compound, and then a chemical name. Usually that's the IUPAC name, and it's characterized by its XRPD signals. And here I've listed 4 of those signals. I've just recited a diffractometer using particular copper K alpha radiation and the wavelength of that radiation. Now, note here I use the word signal instead of peak. I realize it is very common to refer to as XRPD peaks. After all, the algorithm that goes through an XR powder diffractogram does pick out peaks. We call it peak picking. But I in favor of using the word signal. I'll show you why, because in the previous slide, back to it, here we go. I don't know if, depending on the size of your screen, here's a good example. The tallest feature here is indeed a peak, but an infringing a product may show a signal here within experimental air, but you see that off here is a bit of a shoulder, or maybe there's a peak hiding under this peak. So we have 2 overlapping peaks. This is quite common, not only in XRPD, X-ray powder diffraction, but in other spectroscopic techniques where we find overlapping peaks or shoulders of peaks. So instead of insisting that a claim must have a sharp defined peak, it's just best to define that at that particular degrees to theta, there is a signal that clearly is above the signal to noise threshold. And that way, a construed claim would less likely be tied to a sharp peak at this exact degrees to theta, but encompass any signal occurring at that point, even if it is a shoulder. Go back one. I covered this. All right, let's turn to legal aspects of solid forms. And here, I again emphasize practice before the US PTO and controlling case law. I'll finish with a brief survey of some experience in major jurisdictions around the globe. The main issue in patenting polymorphs or any solid forms, I'll stick with polymorphs, generally is anticipation or novelty. From the Continental Can, we know that establishing the doctrine or memorializing the doctrine of inherent anticipation, prior art reference can anticipate without disclosing any feature of the claimed invention if the missing characteristic is necessarily present or inherent in the single reference. And an example of this is in this excerpt of a patent application that describes the synthesis of a compound. This is very typical of a synthesis. It's journal quality. And here we read about a very standard extraction, a concentration of the extracts and standing of the extract, leaving an oil that crystallized on standing to give colorless crystals. And what follows is the typical spectroscopic features, low res, mass spec, melting point, and elemental analysis. What's not described in this example is any description of the colorless crystals. Now, there is no X-ray powder diffraction data given here, no description of the morphology of those crystals, but the exact recipe on how to make the crystals is given. And it could be, I don't know in this case, but it could be that this particular example would constitute an inherent disclosure of a particular polymorph, thereby thwarting a patent applicant from later patenting these particular colorless crystals. So later in 2003, the Federal Circuit and Schering clarified that for inherent anticipation, a person of ordinary skill in art doesn't necessarily need to recognize what that inherent disclosure is at the time that the prior art was created. So here I'm fairly certain that the authors of this example had no idea, nor did they even care what the morphology of these crystals were, whether it exhibited polymorphism and so forth. It's enough that in this case that repeating this example necessarily produces those same colorless crystals. For this reason, I instruct my inventors to describe how to make compounds in the basic patent, but leave off any description of how they were how the compound was finally isolated, and maybe even not include yield, as those features aren't necessary to enable and sufficiently describe the compound. And that way, the basic patent could not be wielded as an inherent disclosure of any later arising polymorphs that the inventors wish to patent. Well, if novelty is the main issue, what about obviousness? Again, from the US, we'll see shortly that the US is a bit of a standout in this regard. The central issue in obviousness is, at least with respect to polymorphs, is unpredictability. Whether a compound crystallizes at all is unpredictable. Sometimes one is left with a foamy solid, a gum, a glass. Sometimes it does crystallize. It just is impossible to predict. If it does crystallize, does a compound exhibit polymorphism? Well, that's impossible to know ahead of time unless the something like a polymorph screen is carried out. But if the compound does exhibit polymorphism, how many polymorphs are produced? I've seen as little as 2 and as many as 8 or 10 for a given compound. And if many polymorphs are or can be produced, what are they? Specifically, what are their properties, their spectroscopic properties? All these 4 questions go to the heart of non-obviousness of polymorphs in the US, and that is the unpredictability. Now, borrowing a little bit from the patenting of small molecule compounds, we know that from well-established patent law that structurally similar compounds are often conceded or asserted as prima facie obvious variants of each other. And if a prima facie case of obviousness must be conceded, then that can be rebutted by a showing of unexpected results. But here, in the case of polymorphism, novel polymorphs are patentable without the need to show any unexpected results. And that's because in the US, obviousness of polymorphs generally is not an issue. But there are signs that may not be the case for too long. I've picked three very recent cases from the Federal Circuit that give some guidance here. I'll go through these fairly quickly and simplifying, but not distorting the facts of the case to focus only on the obviousness issues. So in Grunenthal, the patent claim at issue was directed to a form A, that's a crystalline form of tapentadol hydrochloride. Now, the prior art consisted of two publications. One was one disclosed a form B of tapentadol hydrochloride, and from that reference, there was no evidence whatsoever that tapentadol hydrochloride exhibited polymorphism. The second reference was a reference work by Byrne, the author, who disclosed various approaches to the discovery of polymorphism. In other words, the things that one would carry out for polymorph screening, like temperatures, solvents, and the like. The district court found that the patent was not invalid as obviousness, and on appeal, the Federal Circuit affirmed. Why? Because, referring to the graphic I displayed a few slides prior, there was no reasonable expectation of success. A few of the factors the Federal Circuit thought were determinative was that first, polymorphism wasn't known to occur for tapentadol hydrochloride. Second, there was no evidence that any of the claimed form A could be synthesized. And finally, even though the Byrne reference described factors that one would adjust for a polymorph screen, the reference didn't say how to adjust those to, for instance, steer a compound toward the claimed form A. In red here was a somewhat ominous dicta that their decision doesn't rule out the possibility that polymorph patents could be found obvious. So as of 2019, in the US, patents on polymorphs seem to be safe from an obviousness challenge. A few years later, in the non-precedential decision of Pharmaceuticals, was a further illustration of the safety of polymorphs from a challenge based on obviousness. And here, amongst many patents and issues in the case, was a claim to form A of ibrutinib, which recited the X-ray powder diffraction peaks in the claim. There were four pieces of prior art asserted in a challenge of that claim based on obviousness. First were two separate disclosures of ibrutinib and method of making it, but there was no description of an actual crystalline form in those references. And the second pair of references were general works on polymorphism generally, how to carry out polymorph screens. The district court found that the claim was not invalid as obvious. The court did state that based on the four references, there was a motivation to make a crystalline form, but no motivation to make the specific form A with its accompanying or characterizing XRPD peaks. So again, the determinative factor was unpredictability. In other words, the person of ordinary skill in the art would have had no reasonable expectation of succeeding to make form A specifically based on the prior art. On the Federal Circuit on appeal did affirm and again recapitulated the district court's finding that the unpredictability of polymorph screening was enough. This year, in April, came out a rather mind-bending decision in Salix Pharmaceuticals. Here, the claims were directed to, amongst many claims and patents, but the claims here were directed to rifaximin form beta with recited XRPD peaks. And unlike in the previous two cases I just discussed, here there was only a single prior art reference, which contained a few examples that described how to make rifaximin and how to crystallize it, even though the crystal itself was not characterized. Just at this point, ask you to remember that example from a real patent I presented several slides ago that did exactly this. It described the synthesis, how to crystallize it, but the crystal itself wasn't characterized. And the district court held that, or found that the claim was obvious based on a good reason to characterize the crystal, because because characterizing the crystal is a routine exercise, and the prior art here would have led the person of ordinary skill in the art to detect the crystal. On appeal, the Federal Circuit affirmed the holding of obviousness, and the Federal Circuit distinguished over Grunenthal and Pharmaceuticals by emphasizing that those two decisions came out the way they did because there was no reasonable expectation to produce a crystal, the claimed polymorph. But here, in contrast, it was obvious or routine to characterize a crystal that was already produced by the known or prior art process. The decision is a rather, again, mind-bending exercise. And I was wondering at this point why the court didn't simply find the claim inherently anticipated by the single prior art reference. In fact, the court specifically stated that, or rather acknowledged that inherent anticipation was argued, but the court didn't need to discuss it because the claim was found to be invalid for obviousness. So in my opinion, the court did reach the correct result, that is invalidity, but did so for the wrong reason, that is obviousness, and not instead inherent anticipation. It's difficult to rationalize this particular case with the body of existing case law. Perhaps the court is signaling or making good on its statement in Grunenthal that eventually, under specific facts of a case, that a patent can be held as invalid for obviousness. Turning briefly to the front end of patenting polymorphs, I chose two cases, somewhat dated, but just to illustrate a couple features of patenting. Again, a bog standard claim in the box, and the issue here was a 102B rejection. And I want to emphasize here that it's important to keep the burden upon the patent office to show a sound basis for asserting that the prior art really does anticipate a polymorph claim. And here, the facts of this case, the prior art disclosed white crystals that were obtained by a process very close to the appellant's process, and the prior art did not include any XRPD data, only a melting point. And it turned out what saved the day was a 132 declaration that did distinguish between the claimed and prior art crystals using XRPD and DVS techniques. And here was a way that the appellant, although the burden shifted to him or them, was able to show that there was no prima facie case of anticipation. In contrast, in ex parte ready with a similar claim, and in this case, the claim itself invokes the entire XRPD spectrum in Figure 1. The facts of the case were that the claimed and the prior art processes for making the polymorph were the same. And furthermore, the prior art and claimed XRPD patterns were the same and within margins of error of each other. Unfortunately, the appellants simply uh, showed only that the uh, claimed and the prior art forms had different melting points. And that was not enough to save the day. And the board stated that the difference in physical properties like melting point are well-known variations, and as we know from the bench, melting points can vary depending on purity. And here, the appellants didn't even claim a particular purity of the crystalline form. So, what do we learn uh, from the PTO? Well, first of all, these are not binding upon examiners. A few years ago, I did have a discussion with a senior patent examiner who did reveal an internal effort at the patent office to harmonize examination of solid formed patents. I haven't seen, I would say, a great harmonization, but what we learned here is that, or from these examples, that it's important to disclose and claim at least two orthogonal sets of data like XRPD and solid state NMR or XRPD and TGA. And finally, to the extent possible, distinguish over the prior art process of synthesizing and recrystallization so that the burden always remains on the PTO to show a sound basis for its rejection. And finally, I'm going to whiz through just a few countries here, or major jurisdictions, to contrast. In general, the applicable laws around the world stand the US concept of obviousness on its head. Novelty generally is not at issue anywhere, but inventive step or inventiveness is, where here, for instance, in the EPO, an applicant must prove inventive step based on prior art that discloses the compound and maybe general ways of making a particular or general way of making polymorphs in solid forms, like polymorph screening references. Here, in this case, the applicant merely asserted improved bioavailability, but that wasn't enough. It was what should have been asserted was down here in the lessons section at actual data on a valuable property of such as bioavailability to defend inventive step. And so the EPO, as in other countries, you have to assert more than an advantage. You must have data to back it up. In Japan, in an invalidation trial, again, a similar pattern of a prior art example disclosing the compound and a possibility of recrystallizing the compound, even though there was no crystal actually obtained. Through an appeal, the IP High Court reversed a finding of no in or a finding reversed the finding of patentability and said that it was enough to defeat the claim that there was a synthesis example and a journal way of recrystallizing it, which together constituted a disclosure of the claimed polymorph. And few lessons from this was that it is important to show pharmacological advantages of the claimed polymorph or solid form. In India, I don't have time to go through this decision in detail, but this is the fairly well-known Gleevec decision concerning the claimed imatinib mesylate. In India, the main hurdle typically isn't inventiveness, but rather unique to India, patent eligibility under Section 3D of the Patent Act, which an excerpt of which establishes that a new form of a known substance without enhancement of efficacy is not an invention. In other words, not eligible for patenting. Well, the known substance is equal to what? Salts, esters, ethers, and yes, even polymorphs. So how does one establish enhanced efficacy of these things so that they would be patentable or patent eligible? Well, here, the prior art disclosed imatinib and a journal disclosure of its pharmaceutical salts, including mesylate, and that was deemed to disclose the salt itself. And moreover, the patentee showed that the claimed beta form of this salt was 30% more bioavailable. But the Supreme Court in India held that here efficacy means therapeutic efficacy. It's not, that does not encompass bioavailability. And here we find the distinction between a pharmacokinetic parameter like bioavailability, which was ineffective, and a pharmacodynamic parameter like efficacy that would have been effective. So here would be important if the data is available to show that different polymorphs do give rise to different responses in the organism, much as or akin to dose response curves or properties that you would present for a single compound. And finally, in Latin American countries generally, the results or chances for success are somewhat mixed. In Chile and Mexico, polymorphs or solid forms generally are patentable, particularly if an applicant is able to show the patent offices that there is a corresponding U.S. or European patent. Mixed results in Brazil, Colombia, Peru, and Uruguay, where, like the other countries I just discussed, an applicant must prove inventive step by putting on evidence of some surprising or superior effect. And in Argentina and Venezuela, generally solid form patents will not be able to be patented. And I can verify that from personal experience. Finally, the what we learned from this presentation is don't claim too broadly. We didn't get into enablement or written description, but there is really no such thing as a polymorph thereof or a genus of polymorphs. So I'm not saying it's impossible, but it might be difficult to defend such a broad claim. In contrast, don't claim too narrowly. As I mentioned earlier, claims stuffed with too much data are difficult to enforce, like 10 XRP peaks instead of 4. Know the prior art inside and out, find out whether there might be any inherent disclosures of a claimed polymorph, and that will help to keep, hopefully, the burden at the PTO on the PTO by distinguishing the claim from the prior art processes. I emphasize the need for high quality data in the application. I mentioned journal quality earlier. That was not an embellishment. It really will pay off for a fully described data collection and refinement procedure. And finally, it's good to formulate a global plan for patenting a polymorph. As we have seen in the US, novelty, once established, usually paves the path to patenting. In contrast, in other countries, it is not enough. One must have evidence, hard evidence of tangible advantages like PK or pharmacodynamic data. And with that, I thank you for attending. I think we're out of time, but I'd be pleased to address any questions offline and emails.
Steve, let me throw you one quick question from the audience. That was great. Earlier, you mentioned that Canada is strict about no admission of post-filing data, whereas China takes sort of a middle road. Do you have any experience on the treatment of post-filing data in Korea?
A little bit, and yes, it is possible to submit and have admitted into the record some post-filing evidence of patentability in Korea.
Excellent. Well, we need to wrap this up. If you have any additional questions, please feel free to email Steve. Again, slides for today's presentation are available in the chat, and a link will be emailed to you. The SLW Life Sciences series are held on the second Tuesday of each month. The next seminar will be given on Tuesday, November 12th by John Swart and is going to be about CRISPR-Cas genome editing technology. I hope you'll tune in to the next seminar. Thank you very much for your attention today.